Let's return to This Week in America. Here's your host, Rick Bratton.
Welcome back, everybody, coast to coast. This Week in America. Tort Law and How It's Tied to Our Culture by M. Stuart Madden, Esquire, traces the underpinnings of today's tort law to the written and unwritten rules and norms of societies that existed long ago, how these practices have been adapted to modern times, and how modern tort law fulfills society's goals of compensating the wrongfully harmed for their loss while deterring future harm. M. Stuart Madden is an academic author and a reviewer, past distinguished professor of law, Pace University School of Law, where he taught for 21 years in torts, products liability, environmental and toxic torts, evidence, and constitutional law. A BA in sociology from the University of Pennsylvania, MA History, London School of Economics and Political Science, and a JD Law from Georgetown University Law Center, an elected member of the American Law Institute from 2000 to 2011, and M. Stuart Madden, Esquire, author of Tort Law and How It's Tied to Our Culture, our guest on This Week in America. Stuart, welcome to the program. Great to have you with us.
Thank you, Rick. I'm delighted to be here.
This is a program.
I'll begin.
Yeah, I'm just going to say, this is a program where I think I'm going to learn something, so I'm really looking forward to this. This is something, you hear as a layman thrown around, and this is going to be fascinating to get to exactly what we're talking about here. What would you say would be the central theme of your book?
Well, I believe that your opening narrative touched on my desire to describe the underpinnings of today's tort law to written, unwritten rules of the past. Tort law is a grand anthropological document, whether in the form of a written lesson of myth or folktale or rendered as written law. It reflects a society's superego, a guide to what individuals ought to forego doing in the interest of a community's dignity, safety, and prosperity. Before what would today become the body of civil remedies that constitutes tort law, a loss or injury sustained by an individual would be borne by that individual alone, irrespective of any wrongdoing by the perpetrator. Tort law operates to change that by shifting the cost of the loss from the injured party to the actor responsible for it, making the actor responsible for money damages, a conceitedly imperfect remedy, but the best the civil justice system can provide.
With us on the program is M. Stuart Madden, that's M-A-D-D-E-N, Esquire. His book is Tort Law and How It's Tied to Our Culture. The book available wherever books are sold, Amazon, urlinkpublishing.com. Also, Stuart's website, which is mstuartmaddenbooks.com. All this on our website, and I'll give this to you several times during the program so you can get information and order the book for yourself. Stuart, you mentioned myths and folklore. That's a fascinating topic. What roles have myth and folklore played in the development of tort law?
Well, myth antedates any law or norm of any society. The hunter-gatherer groups, accustomed as they were to a very risky and often dangerous life, possessed myths inhabited by giants and ogres. As they came to adopt agriculture, their myths also evolved. The newer agricultural societies weaned themselves from many of these violent myths and created those more harmonious with lives of reasonable predictability associated with seasons, harvest, and if successful, surplus. Consistent with this idea, many new agricultural societies adopted myths in which the violent giants and ogres were vanquished and often buried by peace-loving figures. Myths and fables provide stories of tribulations, achievements, failures as a roadmap through time towards numerous precepts of modern justice, which include, perhaps most centrally, self-discipline, forbearance, and fairness. As put by Susan K. Langer, man can adapt himself somehow to anything his imagination can cope with, but he cannot deal with chaos.
In one of the chapters, in fact, you devote a chapter to the Greek and Hellenist contributions to modern tort law. Could you explain that, please?
I can, Rick. Among the earliest philosophical tenets that would affect law were those of the Greeks or Hellenists, who defined virtue, morality, and ethics in terms that remain the foundation of Western philosophy and law. The most important instruction of this image of society was that man lives in social harmony with rewards in the measure of neither more nor less than one's just deserts and subordination to the law. For Plato's Socrates, in The Just Man Reason governs spirit. Socrates and others propounded a belief that when a man shed his mortal coil, he would be reincarnated in an animal form. If during his life he had led a life of virtue, he would be reincarnated in the form of an animal respected by man, such as a horse. If, alternatively, a man had strayed from a life of virtue, he might be reincarnated as an insect, even a dung beetle. The Greek philosopher Aristotle, known in his time as the thinker, is credited with laying the cornerstone of the corrective justice principles of the common law. Under the Aristotelian principle of diorthokos, or making straight, at the remedy phase, the court should attempt to, quote, equalize things by means of the penalty, taking away the gain from the assailant. The judge restores equality. This goal of a corrective justice and moral system is meant to discourage harmful conduct. To Oliver Wendell Holmes, quote, the true reference of liability to a moral standard is not for the purpose of improving men's hearts, but it's to give instead a man a fair chance to avoid the harm before he is responsible for it, close quote.
A fascinating conversation, a fascinating book. The book is Tort Law and How It's Tied to Our Culture by M. Stuart Madden, Esquire. It's something, a topic that touches many of us throughout our lives, something that, again, a term we hear, fully understanding it in the book Tort Law and How It's Tied to Our Culture. M. Stuart Madden, Esquire, our guest on the program. I want to go back to something you mentioned before, Roman law. Does ancient Roman law have a role in the development of modern tort law?
It has an enormous role, Rick. Today, perhaps 1 billion people live under systems traceable to Roman law. The book examines Roman law in both its general precepts and particular edicts as they affect today's law of torts. Soon after Emperor Justinian's ascension to be emperor of the Eastern Empire and then the Western, he gave orders that Roman law, both written and unwritten, should be codified. Justinian's great work is the Corpus Juris Civilis, or body of civil law. For Roman orator and philosopher Cicero, justice and morality were not fixed by opinion, but rather by nature. Good men would cleave to equity, fairness, generosity, and the discharge of duty for its own sake. The Corpus Juris includes numerous strictures against the imposition of one's will over those of a neighbor and strong deterrents to the disregard thereof. In one notable example pertaining in what today would be called the law of nuisance or trespass, a particular provision goes so far as to detail a preference that adjoining landowners bargain in advance for agreement as to contemporaneous uses of land that might otherwise trigger dispute. The Corpus Juris provides that one wishing to create such a right of usage, quote, should do so ahead of time by pacts or stipulations, quote. A testator of land might impose such agreements reached upon his heirs, including limitations upon building height, obstruction of light, introduction of a beam into a common wall, construction of a catch for a cistern, an easement of passage, a right-of-way to water, or the obstruction of a neighbor's view.
I know that several Gothic tribes followed the Romans into Europe. Did Gothic law make a contribution to tort law as well?
It did indeed, an outsized contribution. Of the book's treatment of Gothic law, Professor Cerullo, writes, one of the book's several tours de force is a nuanced, compelling account of how the Goths selectively incorporated Roman law into their own codes and Roman norms into their own culture to produce a hybrid civilization. The various Germanic groups were deft in their recognition that in their rule of the kingdoms within the deteriorating and then former Western Roman Empire required a melding of customary law with the Roman law of their Roman subjects. The Goths developed subtle economic incentives to put aside blood feud and adopt instead economic compensation or compensation in kind. The adoption of what was called weregild and also the widespread use of codified tables of compensation to be associated with particularized wrongs, in addition to presaging in many ways modern workers' compensation laws, sent an understandable message of deterrence to those who might turn to mayhem to resolve disputes. The codes adopted distinctions between accidental and intentional harm, as well as evaluations for negligence liability, employing approaches uncannily similar to modern tort law standards of duty and proximate cause. The Goths developed and codified new law and a new social order, the progressiveness of which, when seen as relative to its time, stands on an equivalence with any other populations of the early Middle Ages.
Our guest on This Week in America is M. Stuart Madden, Esquire. His website, mstuartmaddenbooks.com. The book available at Amazon, Barnes & Noble, the usual places. I thank you, our Link Publishing, for arranging our conversation today. The book is Tort Law and How It's Tied to Our Culture. In your book, you explain the difference between common law and the statutory law roles in tort law. Could you explain that a little bit for us, please?
Today's tort law, Rick, is conveyed by both the common law and the judge-made decisional law of courts, called private law, but also by statutes passed by state legislatures, called public law. The book devotes a chapter to the often uneasy interplay between common law and statutory law. Philosopher Jeremy Bentham offered this acerbic observation, quote, common law judges make law as a man makes laws for his dog. When a dog does anything you wish to break him of, you wait till he does it, and then you beat him for it. Close quote. A shortcoming of statutes, on the other hand, is that they do not readily distinguish hues. The statutory solution is confined by the four corners of the statute's language. The problems with such an approach are manifest in the application of the federal sentencing guidelines requiring sentences of a definite range be given to defendants, but giving rise to appalling harshness and inappropriateness of certain sentences while stripping courts of their discretion to depart from them. Statutory solutions to societal problems are also vulnerable to what philosopher John Locke called the dangers of enthusiasm, and the invariable fellow traveler of enthusiasm, haste. Common law jurisprudence, too, has inherent limitations. In applying a common law remedy to litigants, a judge has no meaningful disincentive to subtly gratify his or her own philosophical or social predilections.
In today's favored political debates, I hear so often about so-called natural law. Does natural law figure in the development of modern tort law?
It figures significantly. It's generally supposed that much of the animating basis for early common law derived from an innate, elemental, and sometimes theocratic concept of justice termed natural law. Thomas Aquinas offered the theocratic description that the world being ruled by divine providence, natural law, quote, must be called eternal, close quote, while leading law and economics professor Richard Posner simply equates natural law to, quote, basic political morality, close quote. Natural law and tort law coalesce in the words of Oliver Wendell Holmes, who, contemplating torts, explained, "The general purpose of the law of torts is to secure a man indemnity against certain forms of harm to person, reputation, or estate at the hands of his neighbors, not because they are wrong, but because they are harms." Close quote.
Stuart Madden, our guest on the program, the author of Tort Law and How It's Tied to Our Culture. You write in your book about corrective justice, morality, deterrence, and efficiency. Can someone who's reading tort law, what can they expect to learn about how these themes are connected?
Well, tort law is a model of social expectations, and these social expectations are at once moral and economically efficient. The efficiency norm in particular has organizing principles of waste avoidance, protections of persons and their property from wrongful appropriation, the preservation of the integrity of individual or collective possessions or prerogatives from wrongful interference, and the prudent marshaling of limited resources. The question arises, is common law of tort an effective engine of social change? The New York Court of Appeals put it well, endorsing this, saying, approving application of the doctrine of public nuisance against the generator of waste, even though the defendant did not own the premises constituting the nuisance. It wrote, quote, "The common law is not static. Society has repeatedly been confronted with new inventions through foreseen and unforeseen events that have imposed dangers upon society." Close quote.
Does the law of non-English speaking nations in Europe and the Americas have any system that you can compare to modern tort law?
The law of non-English speaking nations in Europe and the Americas is redolent of these themes. While tort law, in its common law and statutory aspects alike, is an English-speaking province, Europe and South America have civil code systems that provide remedies for civil wrongs or delicts that can be harmonized readily. The Napoleonic Code and the Chilean Civil Code led the vanguard of Latin American law of liability for delicts or daño, resulting in the thorough application of liability for civil wrongs found in the Constitution and statutes of Colombia. All Colombian legal scholars agree that the term responsabilidad, or liability, suggests a link between individuals, a nexus between who or what causes the harm and who suffers it, and has in common law towards one duty to assume the consequences of an act or occurrence or a form of conduct. The elements of such negligence liability are there must be an accident. The accident must be occasioned by the dangerous activity. The person liable must be responsible for that activity, and the injury cannot be the result of force majeure, the fault of a third party, or the fault of the victim. Tellingly, Colombian courts have imposed liability on one who imprudently fires a firearm, and also on one driving a motor vehicle failing to exercise due care.
Such a fascinating conversation. I don't know where the time has gone. We've got a couple minutes left in the program. The book is Tort Law and How It's Tied to Our Culture. Stuart, do you have any closing thoughts on the themes, objectives of modern tort law?
Mr. Braddon, I hope that what the reader takes away from my book is that modern tort law partakes simultaneously of principles of corrective justice, morality, and efficiency. This goal of a moral corrective justice is to discourage harmful conduct. In Holmes' words, quote, "The true reference of liability to a moral standard is not for the purpose of improving men's hearts, but it's to give a man a fair chance to avoid the harm before he is responsible for it," close quote. Just what is Holmes' quote, "fair chance to avoid," close quote, behavior before being responsible for it? In tort, for example, the triggering event for the imposition of responsibility for another's loss takes an actor's knowledge as the starting point, followed by an examination of the circumstances that, quote, would have led a prudent man to perceive danger, though not necessarily to foresee the specific harm, close quote. What are such circumstances? Holmes answers, experience. I want to thank you for watching this podcast. It's my true hope that laymen and attorneys alike will find reading tort law and how it's tied to our culture as engaging an experience as I found writing it. Thank you.
It's been a fascinating conversation. Your U.S. Review of Books says tort law is informative, concluding it's well-researched, engaging, that Mr. Madden's work is a fascinating overview for lay people and professionals alike. It's highly recommended by U.S. Review of Books and so many other very positive reviews. The book name again, Tort Law and How It's Tied to Our Culture. M. Stuart Madden, M-A-D-D-E-N, Esquire is the author. His website, simple, his name, mstewartmaddenbooks.com. Book available at Amazon, Barnes & Noble, all the usual places, urlinkpublishing.com. And you can go to our website, thisweekinamerica.us, and link on directly to Stuart's website, get information, order the book there as well. Stuart, it's been a very informative program, a conversation. Thank you so much for joining us on the program.
Thank you, Mr. Bratton.
It has been a pleasure to have with us on the program Stuart Madden, Esquire, Tort Law and How It's Tied to Our Culture, the name of the book. His website, mstewartmaddenbooks.com. And, of course, you can find all this information on our website, thisweekinamerica.us. And we're back on today's program right after these messages.
This Week in America is online. You can visit our website, thisweekinamerica.us. Scott Pinkerton, Associate Producer of This Week in America. Jay Anderson, Segment Producer. Ben Watson, Webmaster. Otto Bechet, Director of Engineering and TV Production. This Week in America produced and is a trademark of Blue Funk Broadcasting, LLC. For information on all of our guests and to listen to this week's show, our website again at thisweekinamerica.us. And I'm Sean Bratton, Executive Producer of This Week in America.